Are you prepared for some of the most significant changes to your individual retirement plan that has been passed by Congress in the past 10 to 15 years? Hello, my name is Tim McCurdy, and I am an estate planning lawyer in St. Louis, Missouri. Today we're going to be talking about the SECURE Act. Congress recently passed the SECURE Act to make changes to the rules that apply to individual retirement plans. And these plans and these changes may have a significant impact both on your planning for the future for retirement and also on your estate plan and how you're going to leave your inheritance to your family. So today we're going to be talking about what those changes are and how that could impact what you're doing for your retirement plan and your estate plan. As I mentioned, these are some of the most significant changes that have been made in the past 10 to 15 years. And the SECURE Act makes essentially four major changes. First, it removes the contribution age limit for individual retirement accounts. Second, it raises the age when you're required to start taking money out of those accounts. Also, it allows the purchase of annuities within your IRAs or 401ks. And finally, it removes what we call the stretch. Now, you may not be familiar with some of these terms or how that fits with your retirement plan, but we're going to talk about that as we talk about what each one of these changes means for you and your estate plan and your retirement. First, it's important to understand why we have IRAs and what they are. And it's an unfortunate reality that many of us don't have enough money set aside for retirement. It used to be that we would go to work for a company, you work your life there, and then you get a pension from that employer. And that, for the majority of Americans, is no longer the reality or a reasonable thing to rely on. And instead, the burden for preparing for retirement has increasingly shifted to the individual. And one thing Congress has done to encourage people to save for retirement is to create individual retirement accounts where money can be placed to set aside and save for retirement, and you'll get tax benefits. It's either going to be tax deferred with a traditional IRA, or you're going to use after-tax dollars with a Roth IRA, but when you take that money out, you're not going to pay tax on the earnings. And understand that the idea was that you would be putting money into these accounts until you're ready to retire, but once you retire, you are no longer putting money into those accounts. So the IRAs had an age contribution limit that said that once you got to 70 and a half, you could no longer put money into those accounts. You could put the money in, but it would be the same as any other investment account. You wouldn't get the tax benefits of putting into an IRA. Now keep in mind that that age limit was put in place back in the 70s when these accounts were created by Congress, and it had never changed. So what's happened over that time is we're living longer, fortunately, but we're also working longer. So while at 70 and a half, the assumption was when these laws were passed in the 70s that you were retired by then, the reality is that now many of us are working longer, and that at 70 and a half we may still be actively engaged in the workforce. So in recognition of that fact that people are working longer, they've removed that age limit. So now you can continue to add to your IRAs with the same tax benefits as you could before you turn 70 and a half, and you're no longer stopped from doing that once you reach that age. The second part to remember about the IRAs is that it is a tax incentive for you to invest and to save for retirement, but it was never intended to be without tax. So if you have a traditional IRA, it's not a form of tax forgiveness or exclusion, it's tax deferral, meaning that you can put the money into the IRA, but eventually you're supposed to take that money out. And when you do take that money out, you're going to be taxed. So the tax that you didn't have to pay on that money when you invested it, you now have to pay when you're taking that out. So, and we're talking here about traditional IRAs, not Roth IRAs. Roth IRAs are different because you take post-tax dollars. You have the money taken out, you pay the income tax on the money you receive at that time, you invest it, it grows over time. When you take that money out, you don't have to pay the tax. So that's not what we're talking about. With the traditional IRA, once you reach 70 and a half, you're required to take out what they call required minimum distributions. So what this means is when you reach 70 and a half, they would look at your life expectancy and the balance that's in your account, and they would divide it to say how much you have to take out each year, with the goal being that when you reach your life expectancy, you will have taken out the tax or taken out the investments, and when you do that, you're paying tax on the investment. Because this wasn't to prevent you from paying tax, it was to defer it, and when you run the numbers over time, you'll see that you're able to increase your retirement savings much more by not paying the tax, 20 years before you have to pay it, but eventually you're supposed to pay. So originally, again, that was at 70 and a half, the same as the contribution age limit, and you would go through that calculation of the account balance and your life expectancy to say how much was owed. So the Secure Act raises that to 72. So now you have an extra year and a half to have your investments grow tax-free. You have a longer period of tax deferral. So this could, and then again, keeping in mind that you're only required to take out part of it over time. So this is showing both that we're living longer, our life expectancy is longer, so the required minimum distributions are coming out over that period of time, and then also that we're working longer. And again, this is an age limit that had not increased for 30, 40 years, so it's a recognition again that we're living longer and we're working longer. So now we have a bit longer, a year and a half, that we don't have to have the tax come out when we get the money out. Again, just with the traditional IRAs, not with the Roth IRAs. Now, and the third change that we don't talk about very much here is the fact that you're able to purchase an annuity within your IRA, your retirement account. That's something that you would want to talk about with your financial advisor or your insurance agent about, does that make sense for you? Do I want an annuity within that account? And that will have tax savings attached to that. Now, the fourth thing, and the part that could most significantly impact how you have created your estate plan, is impacting what we call the stretch. Now, keep in mind that the traditional IRAs are designed that they pay out during your lifetime. This wasn't intended to be some form of estate planning to where you could take the tax deferral that you're allowed to save for your retirement and pass that on to your children or your beneficiaries and say, okay, when I pass this on, they won't have to pay tax either. So, but one of the things that existed under the law prior to the Secure Act was that if you leave your IRA to your spouse, that can roll over, that can be the spouse's IRA. But if you left that to your non-spouse, your children or other individuals, and you left them your traditional IRA, when you were taking out the required minimum distributions after you were 70 and a half, the required minimum distributions continued, but it would be based on the life expectancy of the beneficiary. So if you're someone who is in their 70s or 80s and you're taking out required minimum distributions when you have a shorter life expectancy, keeping in mind that formula where it's just the division of years and the account balance, your required minimum distributions are rather large. Compared to if you left that to one of your children who say they're in their 40s or their 50s or even younger, it's going to be based on their life expectancy. So if you're 40 and you have a life expectancy of 40 plus years, now you're taking that same account balance, but your required minimum distributions are much smaller because it's being divided up over that longer life expectancy. So now if your beneficiary doesn't need that money right away, if they're able to leave that money in the retirement account, they would have the potential to stretch the savings, the tax deferral, over a much longer period of time, and that could be a significant tax savings for the beneficiaries. Now that's for traditional IRAs. For Roth IRAs, the required minimum distributions that didn't exist for the individual are in place for the beneficiaries. So what we had, especially with the traditional IRAs, was a form of estate planning where individuals were having much longer periods of time to have tax deferral than was ever intended when the IRAs were created. So what happens under the Secure Act is they've tried to prevent that. And what they've done is they've said, they've essentially removed this notion of required minimum distributions being based on the life expectancy of the beneficiary, and they've said that when you leave your IRA to someone other than your spouse, it has to pay out within 10 years. So now it doesn't matter how old the beneficiary is, that whether they're 30 or 40, it's no longer dependent on their life expectancy. It has to pay out within 10 years. And then there are various rules that apply. For example, if you're a minor, then it's 10 years after the minor reaches majority. And there are special rules for individuals with disabilities. But the important takeaway more generally for your estate plan is to know that if you have created your estate plan based on this stretch, if you're using, for example, a trust as part of your estate plan for IRA benefits, it may be an important time for you to revisit that and see how this change with the Secure Act is going to impact your plan. I hope you found this information to be useful. Please keep in mind that this is general information and is not intended to be relied upon to make legal decisions for your own unique needs. And especially, I encourage everyone to speak with their financial planners about their IRA designations and their retirement plans, and also for your estate plan. And it's an important time for you to circle back if you already have an estate plan in place to see how these changes are going to impact that, or certainly if you're thinking about preparing an estate plan, please feel free to contact me and I would be happy to help you see how this new law impacts your estate plan and what changes need to be made to take account for that. Thank you.